Good morning, afternoon, whenever it is. Not legal advice. Like, subscribe, share, comment. Please do that, all that. Please share, please show other people. I try to provide useful information, or I think I'm providing useful information. So please do that. Today we're going to talk about the matter involving Elon Musk, the pay package, today's events, and what I thought about potential issues were that may arise. But before we get into that, I want to just address a couple of minor points. What do you call a stupid fish? An imbecile. The judge had and we're going to talk about judges because we're talking about a case, but the judge had a really tough time making a decision in the bakery case as it was a tough crumb to swallow. Why did the judge, or why do judges wear robes in the courtroom? You don't want to know the answer to that one. And the magician tried to manipulate the evidence, but the judge saw through his smoke and mirrors. Anyway, so bringing people up to speed, there was a decision by the Delaware court where the pay package that was to be provided to Elon Musk from Tesla was rescinded. In other words, it was put back in time, back to 2018, the date. There was talk about what Tesla might do. Would they appeal, or would Elon appeal, etc. Today I saw, so that's Tuesday, that's today, counsel for both sides indicated that they're trying to work out a deal for a stay on appeal. In other words, they're trying to figure out a number to agree upon so a bond can be posting. So this is how it works. Stay means that all action would be frozen, and there would be no ability to enforce a judgment. And I'll explain what that is as we go on, but it's important to keep up. So how do you get a stay? The parties could agree and the judge could sign off. So they could agree that, and I'm just making up numbers just for the sake of this discussion. They could say, you could post a $10 billion appeal bond, and we will accept that, and there'll be no enforcement of the judgment. The judgment in this case that could be enforced, you will see, is the attorney fee award. So that's one way, agreement of the parties. Or if there's no agreement of the parties, which may be the case, one can ask the judge in the trial court to grant the stay. Since the judge in the trial court doesn't seem to be overly fond of Elon and crew, I don't think they will grant that stay. So either by agreement or by the judge, and alternatively, the appellate court could also grant a stay. Now, the trial court could grant a stay, but impose conditions on the grant that make it difficult, and that's why the parties are trying to negotiate what the appeal bond will be. So will the appeal bond be the amount of the potential pay package, $55 billion? Will it be the actual value of that package unexercised, and I think it was about 2.5 billion, or will be at somewhere in between? So, and let's just pick a number. So if we use 10 billion as the appeal bond amount, and I'm just making up a number, how would you get an appeal bond? So if there was an agreement by the parties that they agreed to a stay, but there had to be a $10 billion bond posted to stay enforcement of any judgment, how would you go about getting that appeal bond? You would go to a bonding company. If the bonding company was satisfied with the creditworthiness of the person who wanted to be bond, they would issue a bond in that face amount of $10 billion. They would charge generally 1 to 2% of the face amount of the bond. So if it's $10 billion, 1% I think is $100 million. 2% would be $200 million. So that would be the premium, the cost of the bond. And I'm just giving you an approximation because I think across the country it varies from 0.3% to about 4%. But I think in Delaware it's generally 1 to 2%. So that's what we used. And then you'd have to collateralize the difference. So you would put up, just in our discussion, you'd pay for the bond, $200 million. You'd also then have to have collateral of $10 billion to collateralize that bond amount. Would that be stock, some other property? Who would put it up? But that's kind of how it goes. So We now know the cost. There has to be collateral. Um, we don't know who would put up the collateral. We don't know the precise cost, but that's kind of the setup for it. And there'll be somebody who will write it for money, of course, like any insurance company. So apparently on March 1st, which is coming up, both sides will submit their positions regarding legal fees, the legal fees involved in the case, to the judge. I don't know, it didn't say whether in what format will it be. Will it just be a brief, or will there be motions filed? Because I would expect an attorney fee motion to be filed. And usually, when fees are sought, the plaintiff's counsel, or actually the prevailing party, because defendant can prevail too, but whoever's entitled to legal fees would file a motion. So in California, for example, what the method, and a lot of states use this, and federal courts use this, the method they use to calculate what a fair attorney fee award would be is called the lodestar method. And basically what you do is you calculate all the hours, you multiply it by a reasonable hourly fee, and that creates a reasonable fee. But that also presumes that you're not charging a contingency. So under that circumstance, generally that's how it's done. Now, and again, attorney's fees is the remaining issue in the case, because there was a decision made to rescind the pay package, but it was left open for the attorney fee request by the prevailing party. So they have yet to file the motion. And again, I don't know if it will be on March 1st or sometime afterward, but let's say they filed the motion. And let's presume that we follow what Delaware has done. And in Delaware, this particular judge, McCormick, said, I think in about October of 2023, that she wasn't willing to give large fee awards and class actions and such matters unless the counsel who prevailed provided substantial benefit to the success of the case. And there was a case involved in Delaware that withstood scrutiny in Delaware, called, it was a class action involving Dell. Now let me back up a second. So if you look nationally, what a reasonable fee is for a $1 billion recovery, generally 10%, approximately 10% attorney's fees if you look nationally. That would be about approximate. It's not a high or low, it's not restricted, but about 10%. So on a $10 billion fee, if the amount in dispute was $10 billion, the amount of the attorney's fee award has been averaged about $1 billion, which would be a large fee, by the way. However, in Delaware, in the case I'm going to mention, which is Dell, which is a class action that settled. So it settled, I think, the end of 2023 or middle of 2023, settled for $1 billion without any litigation, without any trial. So they litigated, but it never went to trial. Settled for $1 billion. There was an attorney's fee request. The court evaluated the request and gave the plaintiff's attorneys an award equal to 26.6%, 67% of the total fee. So in that case, I think if the fee award was $1 billion, plaintiff's counsel got 267,670,000. I think that was the award. And there was a challenge to that, and they evaluated that, notwithstanding what Judge McCormick said, that the plaintiff's counsel shouldn't be given some extraordinary fee. And in it, they looked at several factors in determining what an appropriate fee would be in an attorney fee request. Since this case now, before Delaware, involving the Elon pay package, is basically now an attorney fee case. And in evaluating whether the court should reduce or increase an attorney fee request, there's 5 steps or things that the courts in Delaware look at. One is the stage of the case and the benefit that the attorneys have brought. So the stage of the case, in our case, it went through trial. So that would be somewhat that would support a higher fee award. In the Dell case, they never went to trial. So notwithstanding how long the trial is presumed to take a lot of time. Being that I've done trials, it takes a lot of time to prepare even before trial. So if you go to trial, you spend a lot more time on the case, and generally that's why you might be considered to get a higher fee. Two, whether the case was a contingency or not. Now, I don't know if this case involving Elon's pay package, where the plaintiff's counsel had it on a contingency, but my guess is yes. So if it's on a contingency, again, it's more likely to be the value of the attorney fee award is more likely to be upheld. Three, the time and effort of counsel invested. And I have no idea how much counsel, now this is the prevailing party again, the amount of time they put in. I have no idea how much time they put in, but in light of the recovery and the nature of the arguments and the briefing, I've looked at the briefing, it appears that the counsel put in a lot of time. So they would have satisfied number three. And again, it went to trial. Four, complexity of litigation. I think this was the first time this judge ruled on this type of matter in this type of way. It may not be the most complicated case, but it's a novel case and of reasonable complexity. And then the last factor would be the standing and ability of counsel. I don't know the standing of counsel, but the outcome was great because it was a novel result, first time result. So if you used the Delaware factors, which I just stated, and they upheld a fee award of 26.67% in a case that appears to be less intensive in terms of time, it's very possible they could award a percentage equal to or greater than that percentage. Could be less also. And in some cases, in some states, way it works, and it might be applied here too, the higher the fee award, the smaller the percentage, so the overall percentage will get reduced. But there was no reference to that in the decision that was upheld in Dell in October of 2023. So I do not know if the court, if it goes up to the appellate court, if they will reduce any fee award. So just kind of throwing out 25%, and this is not etched in stone. This is just for discussion purposes, because I'm just following it through the stay issue. If it's 25%, if it's $2.5 billion is the amount that ends up being at issue, because that was the value of the real pay package, and you're talking about $625 million in legal fees. And if you're talking about 55 billion, which was the total amount of the package, or I guess the estimated value of the package if it was exercised, then you're talking about over $14 billion. Quite a difference. Both will be appealed. Again, depending on the stay, which I think will be granted in some fashion based upon the bond, although again, I don't know how collateralized. And I don't know if there's insurance that is present, because there was, I'm sure, directors and officers insurance that was involved that may have paid for some legal fees, but in terms of reimbursing legal fees the other side, you'd have to see the policy, but unlikely for those sums. There's probably limits and deductibles, etc. But it's a substantial amount of money. So if in fact, and we're going to know more March 1 when all the additional briefs are in, and then we'll know further as the judge rules. But if we use 25%, that's a substantial sum of money. So who's going to pay those fees? Does it have to be? Does it come out of stock? Is it come out of Tesla? Does Tesla shareholders have to pay the legal fees that arise out of a judgment against the board and Elon? I don't know. We'll have to see how that plays out. But if in fact that there was a substantial sum, that would be a substantial impact, something to be thought of and considered. And how does this impact the move out of Delaware? Because we had all expected, and we were thinking about that Tesla would move out of Delaware, and I still think it's their intention. I think Boring Company's place of incorporation is going to be moved. But it turned, and I guess in Delaware they changed the law where it used to require unanimous shareholder vote to move, and now it just requires a majority. So seemingly they made it easier to leave the state. However, there's a case, it was in 2023, called TripAdvisor, where a minority shareholder, this is in Delaware, minority shareholder sued the controlling shareholder who was trying to move from Delaware to Nevada. The judge didn't block it, but indicated that that the judge was, and this wasn't Judge McCormick. The judge indicated he was troubled with what was going on, but wasn't going to block it. But would Judge McCormick, if a minority shareholder brought an action and indicated that Elon was a controlling shareholder, would they try to block it? Is that possible? I guess it's possible. And I don't think Elon is a controlling shareholder like the shareholder was in TripAdvisor, but it surely appears that the Delaware courts are open to kind of exerting influence, maybe perhaps over and above what they need to do and what they should do. So, just kind of to give you the time flow, March 1, apparently all the documents, or at least some documents regarding the attorney's fees and the agreed upon language in the judgment. So, the parties were supposed to get together, work out the language. We don't know if they will do that, but let's assume they do. Let's assume they work out the bond and everything's in by March 1. And let's say the motion for attorney's fees is filed by March 1 and it's briefed by March 1. I would expect the judge to have a ruling no later than May 1. I would think if that was a final judgment, then Elon would have 60 days to file a notice of appeal. Once the notice of appeal was filed, from there, they would file opening briefs. It would be Tesla, and that side would file an opening brief, and then there would be a reply brief. I mean, a opposing brief, and then a reply brief, and then oral argument. And all that should occur within a 6 to 12 month span. Thereafter, you would get probably a result within 90 days. However that works out in terms of the time period. Probably late 2025 is what I think, something like that. That kind of gives you the time frame. So we will know more March 1, but I kind of wanted to, since I saw the meeting of council about the stay and what the potential impacts were in terms of the cost of the bond, the collateral, who would pay, would shares have to be exposed, who would pay any judgment, is there insurance, all those issues kind of that I discussed here, I thought were interesting and brought up today in that stay matter. And again, I'll bring you more up to speed when I find out about the March 1 proceedings. And again, I think the attorney's fees at this point in time, at least for the plaintiff's counsel, that's what's controlling the day, because if it's some gargantuan award, you can imagine the plaintiff's counsel would be quite happy. Anyway, that brings you up to speed. I'll continue doing it. Everybody have a great day. Be well. Take care. Talk to you soon.